And joining us now, Todd Blanche, former President Trump's lead defense attorney. Mr. Blanche, good morning to you.
Good morning.
Just 9 hours of deliberation for a 7-week case. The jury dispensed with this in rather short order, and it was a sweeping victory for the prosecution. Are you surprised at how quickly it came and the rejection of the defense case in its entirety?
I mean, surprise is probably the wrong word. That's what juries do. You know, juries can decide something in 5 minutes or 5 days, and we don't know what went into their decision or why they decided the way that they did. But this was a verdict that we were expecting. We're going to appeal, and we're going to win on appeal. I mean, that's the goal. The goal is this is a step in the process of our justice system, and the goal is to appeal quickly and hopefully be vindicated quickly.
We'll talk about the appeal in a moment, but many people, analysts, legal analysts on all sides of the issue, looked at this and regarded this as the weakest case, the flimsiest legal foundation for it.
Hey everyone, welcome back to Dr. John Podcast. This is absolutely massive. Trump's own attorney walked into court and handed the judge documentary evidence proving his own client lied under oath, essentially detonating Trump's entire defense against a $500 million fraud judgment himself. Opposing counsel was visibly stunned. It's the kind of scene courtrooms almost never see. Todd Blanche is not some inexperienced public defender who got overwhelmed by the complexity of white-collar litigation.
Witnesses with tremendous baggage. Are you surprised you couldn't convince even one juror to say, I'm not sure I can convict here?
Well, a trial is there's evidence at the trial, but then there's evidence that didn't come in at the trial. And we fought this case for over a year before we started trial in April. And a lot of what came into trial in evidence, a lot of what didn't come in is a reason why the jury obviously reached the verdict they did. So shock and surprise at what happened? Not really. I mean, we didn't think we were going to get a fair shake in Manhattan, and we didn't.
What's the evidence that you think you should have gotten in that would have made a difference?
Well, there's a lot of evidence that should have gotten in that didn't come in. We asked to bring in evidence, for example, of tax records of some of the witnesses. That was one of the theories of the prosecution. We weren't allowed to do that. There's a reliance on counsel theory that would have been, we believe, helpful to our defense that we were not allowed to bring in.
He is a former assistant United States attorney for the Southern District of New York, an office so elite and so aggressive in its pursuit of financial crime that its alumni populate the highest ranks of the American legal profession. Blanche spent years building complex fraud cases from the prosecution side. He knows exactly how these cases are constructed, exactly what evidence is required to establish intent.
The judge, as judges can do, limited in lots of ways our cross-examination of witnesses that made it a challenge. Again, we don't know why the jury decided what they did, but there was a lot more to the trial than just what happened in April.
Do you expect the DA to ask for prison time? It's available in this case. Do you think the DA will request it?
I don't know what DA Bragg is going to do in run up to the sentencing in July. I would hope not. You have under the guidelines and the rules of the court and what normally would happen, President Trump would not face a day in prison. Putting aside the fact he was president of the United States, the conduct that we're talking about is 7, 8 years old, 9 years old. He's a grandfather, a husband, a father. He should not go to prison. I don't know what the district attorney is going to do.
What do we think the judge will do here? Because as you said, for a typical case like this, a Class C, the lowest level felony, somebody with no prior record is almost 80 years old.
Exactly what consequences await a defendant who gets caught lying to a judge? Trump hired him precisely because of that expertise. The thinking was clear and rational. Who better to defend against fraud charges than someone who spent years prosecuting them? Who better to understand the playbook of the other side than someone who wrote chapters of that playbook himself? Blanche was supposed to be the insurance policy, the seasoned veteran who could navigate the treacherous waters of the New York court system and keep his client from drowning in the consequences of decades of financial manipulation.
Not the typical case where someone goes to prison. Do you think the judge will depart from that?
I hope not. We're gonna fight. That's what this process. It doesn't end yesterday when the jury comes in. It's just part of the process. So hopefully not.
Well, it's interesting because the judge now holds Donald Trump's fate and very freedom in his hands. Donald Trump has made no secret of his disdain for this judge, and even on the courthouse steps right after the verdict yesterday, once again called him conflicted, called him corrupt. He's in the past attacked the judge's family, witnesses. the like, been subject to a gag order. Would you advise your client to maybe to dial down the attacks on the judge in light of the fact that the judge is holding his fate in his hands?
It's not just President Trump has complained about the judge. So have I. I mean, there's publicly filed motions about what we believed gave grounds to the judge's recusal. So it's not just President Trump who's complained. It's his entire defense team. And he's trying to get elected. And so it's not my job to tell him how to communicate to the American people about why they should view this case.
Instead, Blanche has become the iceberg that just ripped a hole in the hull. The hearing on that spring day was convened to address the enforcement of the massive fraud judgment that had already survived appellate review. The numbers involved are so large they strain comprehension. $500 million in penalties and disgorgement, asset seizures looming on the horizon. Trump Tower, that gilded monument to a carefully constructed mythology of wealth and success, potentially heading for the auction block.
As something that is other than the right thing and the right way that District Attorney Bragg should be handling cases, and the judge as well. So you're right.
Is it a smart strategy to stand on the courthouse steps and rip the judge who's going to sentence you and decide your fate and freedom in 6 weeks?
I mean, you say rip the judge, but it's also President Trump expressing his very strong views about why he didn't get a fair shake. So, yes, it's a strong strategy. I mean, of course, it means that we have an argument we have to make to the judge who has been criticized, but we still will make that argument, and I hopefully will be successful.
You're confident on appeal?
Yes.
What's your number one issue? Don't give me a legal brief that you haven't written yet.
I think the recusal issue is meaningful. I think the statute of limitations, the way that the background of why this case was brought is meaningful. I think that the witnesses, I do not think Michael Cohen should ever be somebody who can be relied upon to convict somebody.
And then finally, you're going down to Florida. You've got another case, the federal case over the mishandling of classified documents.
Mar-a-Lago, the winter palace where world leaders were courted and secrets were allegedly stored next to ballroom decorations, facing the prospect of a forced sale. This was the most consequential legal proceeding Trump was facing in terms of immediate, tangible financial consequences. The appellate division had rejected his challenge. The judgment was moving inexorably toward enforcement. And into this high-stakes environment, Blanche submitted filings that will be studied in legal ethics courses for generations.
Is it your expectation that that case will not go to trial before Election Day?
I have no expectation. You're right. We're going to be down in Florida next week with my team. We have a 3-day hearing at the end of the month, and there's a lot of work to do, and we'll see.
What was the president's personal reaction once they went behind closed doors and in the waiting room?
I still am today shocked at how he reacted in a very positive way. I mean, there's this public persona of President Trump. He was stronger than everybody around him. I mean, everybody saw when we walked out of the courtroom, he huddled with everybody. That wasn't us telling him what to do. That was him giving us confidence. It really was of what he knew he needed to do and what he needed to say. And he went and he said it, and I was impressed at the way he handled it. I mean, he had to hear guilty 34 times, standing there. And so I think he's committed and he's resolute. I think he feels as strong today as he did yesterday about what's going to happen in November.
Mr. Blanche, thank you for your time on a busy morning. Appreciate it. We should also note that we did invite representatives from the Manhattan District Attorney's Office to join us this morning as well.
Internal legal memoranda from years earlier, documents generated by the very law firm that was now defending Trump, surfaced in open court with devastating effect. What those memos revealed is a time bomb that had been ticking inside Trump's legal apparatus for half a decade. The documents showed that as far back as the period when Trump was seeking loans from Deutsche Bank, his own legal team was internally flagging the dual valuation scheme as a serious problem. They knew about it. They had documented their knowledge of it. They had circulated memos discussing the fact that properties were being valued at one astronomical figure for loan applications and then reported at a drastically lower figure for tax assessment purposes. The memos didn't merely describe this discrepancy as a routine business practice or or a difference of opinion among appraisers. They identified it explicitly as a potential legal liability. They advised on strategies for addressing it. They demonstrated, in black and white text that could not be spun or denied, that the people paid to protect Trump from legal exposure were acutely aware that the conduct at the heart of the fraud case was legally problematic. The implications of this disclosure are catastrophic and multi-layered. Trump had previously provided sworn testimony in which he categorically denied any awareness of valuation discrepancies. He claimed his accountants handled all the numbers. He claimed he was too busy running a global business empire to get involved in the granular details of property appraisals. He presented himself as a visionary delegator, a chief executive who focused on the big picture while trusting the professionals to manage the technicalities. The memos Blanche submitted make a mockery of every syllable of that testimony. If Trump's lawyers knew about the dual valuations and were actively discussing them as a legal risk, the probability that Trump himself was unaware approaches zero. Lawyers do not generate internal memoranda about potential fraud and then fail to mention it to the client who is committing the potential fraud. The attorney-client relationship is built on communication. The existence of the memos creates an almost irrefutable inference that Trump not only knew about the scheme, but was advised about its legal implications and chose to proceed anyway. That is not negligence. That is not a good faith dispute about valuation methodology. That is intent to defraud memorialized in his own lawyer's files. The judge's reaction to these documents was immediate and pointed. A federal judge has a finely calibrated sense for when testimony has been less than truthful. They hear lies dressed up as forgetfulness, evasion packaged as confusion, perjury hiding behind the thin veil of "I don't recall." When this judge reviewed what Blanche had submitted, she did not nod politely and move on to the next item on the docket. She raised the specter of contempt proceedings unprompted. She observed, in language that will haunt Trump's remaining legal battles, that the candor of counsel in producing these documents raised serious concerns about whether the defendant's prior sworn statements had been truthful. That is judicial code for "I believe I have been lied to under oath, and I am now obligated to investigate whether that belief is correct." Contempt of court is not a civil penalty. It is a criminal matter. It carries the possibility of incarceration. A finding that Trump committed perjury could and likely would be referred to prosecutors for an entirely new criminal case, one built not on complex financial transactions requiring expert testimony to explain, but on the simple, provable fact that he swore to tell the truth and then said things that his own lawyer's files prove were false. The question that screams out from this situation is the one everyone in that courtroom was asking silently. Why would Blanche do this? What could possibly motivate a defense attorney to hand the prosecution a loaded weapon and point it directly at his own client's head? The answer is almost certainly not a single factor, but a convergence of pressures that made compliance with the court order the least terrible option among a menu of terrible options. The first and most obvious explanation is self-preservation. The judge had issued a discovery order requiring the production of all documents related to the valuation issues. That order was not optional. It was a command backed by the full authority of the court. If Blanche knew about these memos and failed to produce them, he was personally exposed to sanctions, to a bar complaint, to potential disbarment, and to possible criminal charges for obstruction of justice. A lawyer who knowingly conceals responsive documents from a court order is committing a crime. Blanche spent his career putting people in prison for exactly that kind of conduct. He was not about to become a defendant himself to protect a client who had been caught in a lie. The calculus was cold, and it was simple. Better to be the lawyer who complied with a court order and damaged his client's case than to be the lawyer who went to prison for covering up evidence. The second factor is the internal warfare that has been consuming Trump's legal and political operation from the inside. Blanche has been locked in a bitter struggle with the hardline faction represented by figures like Ed Martin, the Trump loyalist, who was placed inside the Justice Department with a mandate to pursue political vendettas against real and perceived enemies. Martin and his allies view the levers of federal law enforcement as instruments of retribution. They want investigations launched against Biden, against the prosecutors who charged Trump, against anyone who ever crossed the family or the movement. Blanche, with his background as a career federal prosecutor who spent years building cases on evidence rather than grievance, has been a persistent obstacle to that agenda. He reportedly went directly to Attorney General Pam Bondi and argued that Martin was pushing investigations that lacked any legal foundation, that the Department of Justice was being steered toward a cliff by people who did not understand or care about the institutional damage they were causing. Bondi, whatever her other loyalties, apparently recognized the danger and removed Martin from certain sensitive matters. That act of internal sabotage infuriated the Vengeance faction. They began working to marginalize Blanche, to push him out of the inner circle, to paint him as insufficiently committed to the cause. A lawyer who is already on the outs with his own client's political machine has significantly less incentive to risk his career protecting that client from the consequences of his own dishonesty. The third possibility is the most human one. Blanche may simply have had enough. Representing Trump is not like representing a normal client. Normal clients listen to advice. Normal clients do not publicly attack their own legal team. Normal clients do not have a documented pattern of throwing everyone around them under the bus the moment they become a liability. Blanche watched colleagues get chewed up and spat out. He watched lawyers who took bullets for Trump get discarded the moment their usefulness expired. He watched a client who demanded absolute loyalty while offering absolutely none in return. At some point, the most rational calculation for any professional is to prioritize their own integrity over the interests of someone who will betray them the first chance he gets. The memos were coming out one way or another. The court order made that inevitable. The only question was whether Blanche would be standing on the right side of the disclosure when they did. The fallout from this betrayal is cascading through every dimension of Trump's legal and political existence. The civil fraud defense, already on life support after the appellate division's rejection, is now clinically dead. The entire strategy was built on the premise that Trump lacked knowledge and intent, that he was a hands-off executive who trusted his accountants and could not be held personally responsible for discrepancies he never reviewed. The memos prove the opposite. They prove that the legal apparatus surrounding Trump was not only aware of the dual valuations, but was actively engaged in managing the legal risk they created. If the lawyers were managing the risk, the client was aware of the risk. If the client was aware of the risk and proceeded anyway, the client committed fraud. The $500 million judgment is now secured by a foundation of evidence that Trump's own team provided. Appeals are futile, asset seizures are inevitable. The only remaining question is which properties get taken first and how quickly the auction block fills up. The perjury exposure is even more dangerous because it cannot be discharged by bankruptcy or delayed by appeals. Perjury is a crime against the court itself, a direct assault on the integrity of the judicial process. Judges take perjury personally because every lie told in a courtroom undermines the entire system of justice they have sworn to uphold. When this judge reviews the memos against the transcript of Trump's testimony and concludes that the two cannot be reconciled, the contempt proceedings will begin in earnest. The evidence is not circumstantial. It is not dependent on the credibility of a cooperating witness. It is documentary. It is words on paper created by Trump's own legal team at a time when they had no incentive to fabricate and every incentive to be accurate. A perjury conviction carries prison time, and unlike the sprawling conspiracy cases that take years to try and can be picked apart by skilled defense counsel, a perjury case built on conflicting documents is straightforward and hard to beat. The political damage is equally severe because it undermines the central narrative that has sustained Trump through every previous scandal. He has always positioned himself as the victim of external persecution, the target of a deep state conspiracy, the prey of dishonest media and corrupt prosecutors and partisan judges. The enemies are always outside the gates. The betrayals always come from the other side. But Blanche is not outside the gates. Blanche was inside the citadel. He was handpicked, trusted, elevated to the most sensitive role in the most important case. When someone like that turns and reveals that the emperor has no clothes, the psychological impact on supporters who have been told for years that all accusations are fabrications is potentially devastating. The logic is inescapable. If Trump's own lawyer is now producing evidence that Trump lied, how many of the other denials are also lies? How many of the other accusations are actually true? The wall of denial cannot survive when the people inside the wall start dismantling it from within. The chaos inside the legal team is now an accelerant spreading to every other case. Other lawyers representing Trump in other matters are watching Blanche's situation with undisguised terror. They are reviewing their own files, wondering whether they hold documents that a court might one day order them to produce. They are weighing their own exposure against their clients' interests. The rational calculation for any attorney in this environment is to get ahead of the disclosures, to cooperate, to demonstrate candor to the court before someone else does it first and paints them as complicit in a cover-up. The cascading defections that could follow from this single hearing would leave Trump without effective legal representation in the middle of multiple ongoing proceedings. A defendant who cannot keep his own lawyers from turning on him is a defendant who is heading for catastrophic loss in every courtroom he enters. The financial timeline has now accelerated dramatically. The 30-day window for prosecutors to begin identifying and moving against specific assets was already counting down when Blanche submitted the memos. The destruction of the remaining defense arguments removes any plausible basis for further delay. The properties are not protected by legal ambiguity or pending appeals anymore. They are protected by nothing except the logistical complexity of the seizure process itself. Trump Tower, with its bronze glass and its famous address and its symbolic centrality to the entire Trump mythology, could be scheduled for public auction while the contempt hearings are still underway. The humiliation of watching the physical monuments to his claimed success get sold off to satisfy a fraud judgment, while simultaneously fighting perjury charges, while simultaneously facing impeachment proceedings, while the markets crater and the war goes badly and every institution he has attacked begins to push back, is a convergence of pressure that would break almost anyone. The reaction from the man himself was as predictable as it was impotent. The social media platform lit up with denunciations of disloyal lawyers and witch hunts and claims of persecution. But the rage is hollow because it cannot change what the documents say. Trump can attack Blanche's character all he wants. He cannot unring the bell. He cannot make the memos disappear. He cannot explain to the judge why internal legal documents prepared by his own defense team corroborate the very fraud allegations he swore were false. The performance of fury is all he has left, and it is not a legal strategy. It is a symptom. It is the sound of a defendant who has run out of defenses and is left with nothing but noise. The broader collapse this moment represents is difficult to overstate. The military leadership has been purged and is openly contradicting his version of events. Key political allies are publicly mocking him on live television. The Epstein files are being released and revealing connections his administration tried to bury. The impeachment proceedings are gathering momentum in Congress. The markets are in freefall. And now, in the middle of all of it, his own lawyer walks into court and proves he committed perjury. The coordination of the betrayals is not a coincidence. It is what happens when a political figure who has governed through intimidation and loyalty tests reaches the point where the cost of loyalty exceeds the cost of defection. People who once calculated that protecting Trump was the safest course for their own survival are now recalculating and reaching the opposite conclusion. They are looking at the trajectory of the fraud case, the trajectory of the impeachment, the trajectory of the war, the trajectory of the market, and they are deciding that the ship is going down and they do not intend to be on it when it sinks. Blanche's decision to comply with the court order and produce the memos is not just a legal event. It is a bellwether. It signals to every other person sitting on damaging information that the moment for disclosure has arrived. It signals to prosecutors that the inner circle is cracking. It signals to judges that the truth is finally surfacing after years of stonewalling and denial. The legal system has many flaws and many delays, but it possesses an inexorable quality once the facts begin to emerge. You can fight facts with lawyers for a long time, but you cannot fight facts with lawyers forever, especially when the lawyers themselves start handing the facts to the other side. Trump has now reached the point where his own attorney has chosen the truth over the client, and that is a point from which no defendant fully recovers. The walls are not just closing in. They have begun to collapse, and the person standing in the middle of the rubble is the one who built the structure on a foundation of lies and is now being buried by the weight of the evidence his own people have provided.